Joining us now is Mario Nicholas, an attorney who was part of a team that represented the 6 Colorado voters who brought this case. Mario, thanks for joining us. First, just your reaction to the court's decision.
Thank you for having me. Our reaction is we think the court made a fantastic decision. They made a well thought through decision. It's over 130 pages, just the decision. And I think that we have a very good chance going forward if Donald Trump does, in fact, decide to appeal.
So this was a 4-3 decision, though, which we mentioned, and that's important because it wasn't unanimous. And these were all judges who were appointed by Democratic governors. Does that give you pause at all about what the U.S. Supreme Court, which is 6-3, might do with this?
It doesn't. I think it's important to note that the judges that did dissent here, 2 of them dissented on state law grounds, which the U.S. Supreme Court is not going to review. So really what you're looking at is more of a 4-1. And I think that one of the things you have to look at is how detailed the majority's opinion here is, how much it went into. The legal standards that it set out are so well thought through and so well documented that we think we've got a really good chance at the U.S. Supreme Court. For example, they quoted Justice Gorsuch, who did remove a presidential candidate from the ballot here in Colorado previously, about a decade ago, little over a decade ago. So I think when you look at that and you look at the case law and you look at the history that we have from the time that this was adopted, the 14th Amendment was adopted, we have really strong arguments before the U.S. Supreme Court.
One of the dissenting opinions in this case comes from the Chief Justice on the Colorado Supreme Court, who writes this: "My opinion that this is an inadequate cause of action is dictated by the facts of this case, particularly the absence of a criminal conviction for an insurrection-related offense." So, Mario, if Trump hasn't been convicted of any insurrection, can he be punished for engaging in an insurrection?
Well, so I have a great deal of respect for Chief Justice Boatwright, but I think he just got this plain wrong. And the reason is because the 14th Amendment is not a criminal statute. We're not imposing some sort of criminal punishment on him. It just says he's not eligible to run for office again. And that's what the Constitution says. It's a different standard of review. It's not beyond reasonable doubt like in a criminal hearing. In this case, we cleared the clear and convincing bar. And furthermore, the history of the 14th Amendment says that that's just wrong. Many Confederates were never convicted of a crime, but were barred from actually holding office or running for office immediately after the passage of the 14th Amendment. So the history of the 14th Amendment, which I think is important to SCOTUS members, when they look back and they want to go through originalism and they want to go through textualism, they want to say, well, how did the people who wrote this, how did they act? Well, they didn't require convictions. And so I think that's going to be incredibly important here. And that's why the Chief Justice got that question wrong.
One of the key questions here is whether Section 3 of the 14th Amendment covers the presidency. Initially, the district court there in Colorado concluded that the presidency is not an office, civil or military, under the United States. And because of that, the district court had ruled in Trump's favor. Can you explain why you believe Section 3 of the 14th Amendment does apply to Donald Trump?
Yeah, and this was something that we argued at length before the Colorado Supreme Court. It's parsing words about whether the president is an officer of the United States or an office under the United States. And we think that it was very clear, and we set this out in our briefing and argued it before the Colorado Supreme Court, and I think they understood it, that it wouldn't make any sense for the president not to be an officer of the United States, and for the most powerful position in the country to be exempt from the same thing that they were trying to stop people from doing after the Civil War. For example, if their reading was right and he wasn't an officer of the United States, Jefferson Davis could have been president after Abraham Lincoln. There is no one who drafted the 14th Amendment who thought that that would be appropriate.
Just real quick,
and in this case, go ahead.
No, I didn't mean to interrupt you, but I do want to ask before I let you go. This is obviously a legal win for you, but are you worried at all about the political upheaval this will cause?
Look, the way that we look at it is you can't pick and choose what parts of the Constitution that you abide by. That's the Constitution that we live by as Americans, and it's a rule of law country. And if we don't have rule of law, then we don't have much of a country. And so that's the important piece to us. I think that's what we have focused on. And certainly we think that political upheaval, if we abandon the rule of law, will be far greater than if we say, hey, we need to make sure that everyone is playing by the rules and that we have a country that is worth defending and a constitution that is worth defending.
Mario Nicholas, thank you very much for joining us. I appreciate your time.